hear from the appellant.
Good morning, Tyler Chastain for the appellant, Magnolia Pointe Homeowners Association. I'd like to reserve 3 minutes, please.
That will be fine.
Thank you, Your Honor. Your Honor, this is an interesting case in that we have only succeeded to the motion to dismiss stage with 2 amended complaints. It was for enforcement of a restricted covenant contained in a declaration of covenants and restrictions that was filed. The motion to dismiss came by counsel for Ms. Mitchell asserting that the restrictive covenants did not apply to her property, which is Lot 30 in the Magnolia Village, Magnolia Pointe subdivision, due to the fact that it was not in her chain of title. That was briefed by both sides, and our second amended complaint attached exhibits K, L, and M, which addressed how that property was in that chain of title. And that went before the argument of the Knox County Chancery Court. And then the decision that was rendered by the court granted the motion to dismiss, but as the court would recognize in the opinion, Chancellor advised that he was ruling sua sponte and found that the word outlandish under Article 12, Section 4, which is the dwelling restrictions for landscaping, that word as part of that entirety of the provision was vague and thus made the provision we relied upon unenforceable. Exhibit I to the amended complaint contains the photograph of the statute yard ornament, which was that issue which the Homeowners Association requested be removed. The statute, the provision says outlandish rock garden statutes or yard ornaments greater than 3 feet to height and 3 feet in width will not be permitted in the front yard area. For the purposes of this motion, the court would have to take notice that the statute was that the yard ornament was never challenged to not be 3 feet in height, 3 feet in width, or in the front yard. The only issue which the court found to say that the provision was not applicable, it was the use of the word outlandish, said that made the provision vague and unenforceable. One of the things that the court focused on, and I'm going to that part of the decision because even though the party spent an enormous amount of time briefing the issue of chain of title and went to get declarations as to how that title, how the restrictions became relevant, this court, the Chancery Court, said that wasn't the basis for its decision. So I'm moving to the court's decision when it specifically said that because of that word outlandish that this provision could not be enforced. Looking at that, the court specifically excluded the last part of that provision, which discussed the 3 feet in height, 3 feet in width, and in the front yard. Essentially, the court ignored that provision, said that that had no meaning. I would direct the court through our brief to the case of Avalon 4, 6, and 7 versus Chidari, which was decided back in 2014. And in that case, the trial court concluded that a restricted covenant was vague and the enforcement was very subjective. This dealt with landscaping as well. And the Court of Appeals and the trial court said that these restrictions, though vague and subjective, were still enforceable as long as the homeowner is on notice of the board's general authority and the board follows its own appropriate procedures in enforcing the covenants. And we never got that far in this case. We never had that issue come before us. It wasn't addressed to either counsel at the time that, hey, I want to look at the issue of outlandish, whether that's ambiguous, whether that would make this entire provision unenforceable. The court in this situation, looking at the Avalon case, could clearly acknowledge that it stated that a disapproval or approval of an improvement is whether it's reasonable. They said it was a factual question to be determined in light of the circumstances. Our trial court raised one question as part of its basis for finding unenforceability when it said who was going to be the arbiter of this word outlandish, who was going to be the arbiter of determining what should occur. Because as the court pointed out, if the prohibition applies to outlandish...
Counsel, you keep talking about who is the arbiter, but I'm looking at the notice of violation that's attached to the verified complaint, and it mentions nothing about a board determination that this, whatever it is, violates the CNRs, it basically says it's higher than 3 feet and it violates. So it doesn't seem like there's any arbitration or decision-making going on there at all. Isn't that a fair statement of what happened here?
Exhibit J that Your Honor is referring to, that's what it does state. And what the Avalon case said, if let's say the homeowner comes back and says this is vague, this is ambiguous, and it shouldn't be enforced, the arbiter then would have to, meaning in this case the homeowners association, would have to present facts to show why it made that decision. Was this in harmony with the rest of the neighborhood? Was this in harmony with the design and the scope of what they intended to enforce, and also what may have been enforced in the past? So you're correct, Your Honor. There was not there was not a provision by which the parties got together, had any type of hearing or anything of that nature. The trial court, though, posed a question: who is the arbiter of what constitutes outlandish? And that is, I was referring back to the Avalon case where the court said, if we have a factual determination of whether the homeowners association would be acting properly in the enforcement of a restriction, they would have the right under even Article 12, Section 4 to make that determination. Now, if they brought a claim and says this is not, it meets all the standards at this point, if the word outlandish didn't apply, there would be nothing to show that it didn't meet each of those standards. We wouldn't even have to have an arbiter. You would simply say, if you measure it, it's 3 feet in height, 3 feet in width, and in the front yard, that provision would be applicable regardless, Your Honor.
So if it is taller than 3 feet, it's by definition outlandish. Is that what you're saying?
If you take all the words of that sentence, by definition, outlandish yard ornament would mean something more than 3 feet in height, 3 feet in width, and in the front yard.
It has to be both.
Yes, Your Honor.
Okay.
That's the way you would read that entire sentence as an entirety. If you read it simply as using the word outlandish, as the trial court did, and did not include the last portion of that provision that talks about the height and width and location requirement, then the trial court has left that provision off in its analysis of this provision.
But I guess your interpretation leaves out the word outlandish, does it not? I mean, if I say, if I read Section 4 as reading rock garden statues or yard ornaments greater than 3 feet in height and 3 feet in width will not be permitted in front yard area, that gets you to the same place that you're suggesting this provision goes, does it not?
Yes, Your Honor.
So you don't really need the word outlandish at all.
I would love the word outlandish not to be present, Your Honor. Yes, Your Honor. I don't have that pen available, though, Your Honor.
You said earlier, counsel, in your argument about how the CNRs got in the chain of title here, but it doesn't seem to be any dispute that they weren't in the chain of title in the case of Lot 30 here. Is that correct? In the case of this lot, no question here that the CNRs were not in the chain of title, correct?
We think
for this particular lot.
We think they were. We just think it was not specific. They filed the final plan of development. I think the actual the word Lot 30 was not shown to be in there, and I believe that is why we had to file those declarations of Mr. Merrill that we filed along with the original showing that these were included in her.
So the original, the 2004 CNRs had the plat attached?
They referenced the plat that was being filed with the Knox County Register of Deeds, Your Honor.
Okay. And then that plat showed this lot, just not as numbered lot.
That's my understanding, Your Honor.
Okay.
Yes, Your Honor. And that was June of 2004. The plat was. That's when they had the CNRs were filed at that point, Your Honor. Okay. And then continue the title going forward for the deeds of the property. Reference the plats and the CNRs, and in the appellee's deed, it was also referenced that this is also subject to restrictions. This is not a situation of an after recorded CNR after the appellee had purchased the property.
But there's no dispute that in this 2004 filing is the CNRs now I'm talking about, it's missing Exhibit A.
I believe that's correct, Your Honor.
Okay.
All right, let me take you back. I'm not sure I understand. Is it your position that, or your client's position, that the word outlandish isn't necessary to be found if it's greater than 3 feet tall? It's a statute that's, or yard ornament that's greater than 3 feet tall.
The way I would, to read the entirety of the sentence, the outlandish would be defined by the 3 feet width. I don't think I can't leave the word outlandish out. And
So
then
if it's 2 feet 11 inches, it's not going to be outlandish no matter what.
the way if you read the sentence in its context, Your Honor, I would agree with that statement. If it doesn't meet those, and be in the front yard, yes, Your Honor.
Okay.
As we know, covenants and restrictions are often drafted by people who don't think about these things, but in this situation, if you read the entirety of the sentence and of that last part of section 4, if you can't leave out any of the words, and outlandish, that's descriptive of what it has and defines it. So we believe that's the provision, how you have to read it in its entirety. And the trial court simply used the word outlandish and did not consider any part of the size or location issues. So that really basically was immaterial. I know I'm running short of time here, and I just wanted to bring back one other point from this Avalon case. You don't really find a lot of cases that have a very good description of a case that's close to you have. But the court said in that case, the most important criteria applicable to the termination, and this is of a CNR that was found to be vague by the trial court, is whether there's lack of compliance with specific restrictions of the subdivision and the construction that is not consistent or harmonious with overall plan of development. And that's when they looked at what would be the overall, what would be harmonious and overall plan. And that's why if you look at the entirety of section 4 with the height, width, and location restriction, all that would have to be necessary for the determination, even if the word outlandish makes it vague. I see I'm out of time, Your Honor. Thank you.
Thank you, counsel. You have your time for rebuttal. We'll hear from the appellee.
Morning, Your Honor. Howard Jackson for the appellee, Ms. Mitchell. This is a case where the homeowner association is attempting to enforce an unenforceably vague restriction that was never effectively created in the first place against an owner with no notice. In terms of the effective creation, we note, as the court referenced earlier, that these restrictions come in the 2004 declaration that references in Exhibit A, and the Exhibit A was not filed. It was never filed. So you've got a restriction stated, but they're not connected to Lot 30. And then you've got the chain of title, and we went through that in our brief. I'm not going to take the time here to do it.
So does the first CNR, the 2004 CNR, reference a plat, and was the plat filed, recorded at that same time?
It references Exhibit A as a plat, which was not filed at that time.
I see.
Not filed. And that set of circumstances, the failure to file, and then the subsequent chain of title, which we walked through with no reference to it in the subsequent change of title, brings this case within the Phillips versus Hatfield Tennessee Supreme Court case that we cited in our brief that says if you want to have restrictions that run with the land, you've got to not only have the intent for them to run with the land, they have to be effectively created in the first place. As to Lot 30, in this specific set of circumstances, they were not effectively created. That's pretty much a period, I think, Your Honor, if we follow the Phillips case. There's been talk of also an implied covenant in the briefing, otherwise, an implied reciprocal covenant and equitable servitude coming up. Well, again, one requirement is you've got to have the covenants effectively created in the first place. That's the Phillips case. But then you can look at the Lutzak versus Phoenix American Development Partners case, which we cited in our brief, in which provides very specifically that you can't have that implied covenant when the developer expressly retains the right to change the restrictions. And that is the case here. The developer reserves its right in its absolute discretion at any time to amend, waive, change, or modify any of the restrictions. We quoted that provision at page 25 of our brief.
On the argument about equitable servitudes, wouldn't it be enough if your client was told there are CNRs in place here and your property is subject to those?
That was specifically addressed in the Lutzack case, Your Honor. On the last page of that decision, defendants proffered evidence that the trust had actual notice of the common plan does not change our conclusion, because this plan, that would have necessarily included notice of the developer's right to change it. And so that wasn't enough in the Lutzack case.
So, but Lutzack qualified that by saying the developer had a right to change it. Was there a provision in these CNRs that said this can be changed at any time?
In the declaration, yes, exactly. We quoted that on page 25 of our brief. It says, I've got a small part of it here, developer reserves the right in its absolute discretion at any time to annul, waive, change, or modify any of the restrictions here. So those provisions bring us within the Lutzack case in terms of any kind of equitable servitude. Then there's been talk about ambiguity in the provision. The trial court referenced that.
Well, that was the basis for the trial court's
That
decision.
was the basis for the trial court's decision. We submit there's other basis here that the trial court was right for other reasons, that that's acceptable. But in this situation, I think it's important to remember the principles of construction here. And again, I would like to refer the court to the Phillips versus Hatfield case at page 475. This is how courts are required to look at restrictive covenants. Tennessee courts construe them strictly. That's a quote. Thus, if the right to enforce the covenant is doubtful, such right will be denied. Similarly, we have stated that any doubt concerning the applicability of a restrictive covenant will be resolved against the restriction and in favor of the property's unrestricted use. Finally, when the terms of a restrictive covenant can be construed in more than one way, courts must, and the court uses the word must, courts must resolve any ambiguity against the party seeking to enforce the restriction and in a manner that advances the unrestricted use of the property. So if we're talking about a restriction, this is a direction from Tennessee Supreme Court about how the lower courts must, that's a quote, look at these restrictions. And the trial court did that. You got outlandish statues, yard ornaments, etc. Okay, what's outlandish? That's subject to a lot of interpretation. That's ambiguous. That's vague.
Would it make any difference in how the provision was applied during the course of the history of the subdivision? Let's say, for example, that it was consistently applied in the manner that the homeowners association suggests here. It only applied based on height and width of the structure. I mean, isn't that an important fact to know in determining whether or not this provision is enforceable?
Well, I think if you, under the principles of the construction, if you look at it and there's a challenge, I mean, the homeowners association may have applied it in 50 different ways over time. We don't know.
What if they were always consistent? It always, in every instance, they only invoked it if the yard ornament, or I can't remember, the rock garden was higher than 3 feet and wider than 3 feet every single time.
I think that the courts are required by this language from the Phillips case to look at the language of the agreement and to understand. And if there is ambiguity there on the document.
But if the homeowners association doesn't apply it in such a way that you invoke this outlandish provision, I mean, then there really isn't any ambiguity at all, is there? I mean, it seems like we would be searching for an ambiguity in that instance if the homeowner association said, I know it says outlandish, but I only care, is it taller than 3 feet and wider than 3 feet? Wouldn't that make a difference here? And it seems like to me that's a fact we don't know here because this went off on a motion to dismiss.
It is a fact. It's not on the record. I mean, there's no doubt about that because there was no discovery about those sorts of things. But my contention would be that if we had 50 consecutive enforcements with no challenge to the language or the application of it, it went on and it is what it is. But in the event of a challenge, then we're required to look at what happened in this case under this language.
And in this case, there wasn't any suggestion, your client didn't respond to this notice of violation letter. Well, wait a minute, it may be taller than 3 feet, but this is certainly not outlandish. I mean, they didn't respond that way either, so they didn't seem to be confused about the term. Now, I appreciate that your client is saying, well, they don't apply anyway.
Right.
But that wasn't the response to this notice of violation letter either. This is not outlandish.
That was the finding of the trial court.
Right.
And I want to address briefly one other thing in terms of this, the notion of, well, who is the arbiter of what's outlandish? And there's been a suggestion that maybe it's the HOA board, but the documents don't say that. They just don't say it. There's no provision that just comes out and says, we do this. There's architectural review when you're going to add a garage or something like that, but that's in a separate language from the enforcement of these particular restrictions, and particularly the one today about the yard ornaments and statues, et cetera. And so that doesn't help. And so in closing, I would just again reiterate that there are rules of construction here about what a court must do if there is some ambiguity, and clearly there is ambiguity in the restrictive provision that's at issue in this case. And for that reason, as well as the others we cited, we would urge the court to affirm the trial court's decision. Thank you.
Thank you, counsel. We'll hear from the appellant rebuttal.
Thank you, Your Honor. Just 3 specific points. First, under the Rule 12 standard for the review, we have to accept for the fact on this motion that the structure was more than 3 feet in height, 3 feet in width, and in the front yard, because that's what was in our pleading. So the court would have to take that as true for the purpose of analyzing this case. We also addressed the equitable servitudes provisions, and as has been held by the Court of Appeals in the past, an equitable servitude binds a remote grantee if it shows that the restrictions touch and concern the land, which I believe those restrictions do. They talk about the HOA, the Magnolia Pointe in the subdivision. The original parties of the covenant intended to run with the land and bind the grantees. That's what we filed through those exhibits K, L, and M as part of the amended complaint that gave facts to that. And the remote grantee, that would be the appellee in this case, had notice of the covenant. It was provided that she also complied with the covenants throughout the time of her tenancy living in Magnolia until this time. She submitted a plan for architectural review for a structure, paid her dues, attended meetings to say that she had no knowledge that there were restrictions, would not be in compliance with what the facts are that have been pled. And as the KLN Associates case that we cited from the Court of Appeals ruled that otherwise valid restrictions are binding, even when they're not in the chain of title, if the owner had actual knowledge of the restrictions when it acquired the property. It's clearly in her deed that she got from the Straters as to Lot 30 that says that there are restrictions on this property, and it was provided as Concord title provided in one of the declarations that she received a copy of those restrictions at closing as well when she purchased the property. Those are the items I'd like to cover in rebuttal. I appreciate the court's indulgence for our argument.
Was that alleged in the complaint, the amended complaint, that the CNRs were provided at the closing?
Yes, Your Honor.
What paragraph is that? Do you know?
Your Honor, as attached as Exhibit L to our amended complaint, we had the affidavits, the custodian of records for Concord title that specifically referenced and referenced that she was provided those restrictions at the time of closing.
It's Exhibit L?
Exhibit L, Your Honor.
Thank you.
Thank you.
Of course, thanks to counsel both sides. We appreciate your briefs and the oral argument this morning.